Former President Donald Trump is scheduled to give a video deposition tomorrow in New York. It centers on a case involving an alleged assault during a 2015 demonstration outside Trump Tower. The lawsuit alleges that Trump's then head of security, Keith Schiller, hit one of the protesters who was demonstrating against Trump's immigration rhetoric. For more on this, let's bring in Kara Scannell. Kara, what more can you tell us about this case and the former president's scheduled deposition?
Well, Fred, this is the first time the former president will give sworn testimony under oath since leaving office. And like you said, this is a case that stems from a 2015 lawsuit where some demonstrators outside of Trump Tower said that they were assaulted by Trump's head of security, the then head of security, Keith Schiller, when they were protesting against Trump, who's then the candidate's anti-immigration rhetoric. So Trump will sit for this deposition tomorrow. It will be videotaped. And the lawyer who will be questioning him, representing these men, is likely to focus on a couple of key areas. He's likely to try to figure out what Donald Trump's knowledge and role was about the security response here. And because they are suing for punitive damages, he can also explore Trump's net worth and his financial condition. And because this also involves security, it's likely that he can ask questions about Matthew Calamari, that's Trump's top security officer, the person who's the chief operating officer of the entire Trump organization, and his compensation. And that is a very issue that is at the center of an ongoing criminal investigation by the Manhattan District Attorney's Office. Now, as part of this litigation, the former president has previously denied any knowledge of this incident, and he had deferred all security to Matthew Calamari, he said, but he will be answering these questions under oath. It will be videotaped, and that videotape will be shown to a jury when this case goes to trial. Fred?
All right, Kara Scannell, thank you so much. Now let's talk more about this. Laura Coates is a CNN senior legal analyst and a former federal prosecutor. Laura, so good to see you. All right, so what can we expect from this videotaped deposition with Trump?
Well, you know, as Kara talked about, Fred, the idea of a former president in general being deposed, let alone one who we don't yet know to what extent he has got self-control. Can he confine his comments to just what he is being asked about? Or will he be more elaborative on a lot of different issues? That's going to be the key here. Remember, there are so many things that are fair game now. Now, this case does not involve what he personally observed. It's very important to note. He's not being alleged of being the person who was presently there, but it's his rhetoric and his statements that they're saying make him legally responsible. I would suspect a president who spent all of his time or most of his term talking about the idea of not wanting to be held accountable for the actions of others based on what he perceived as First Amendment rights, that he will be very steadfast to say that this was not his doing, that this was somebody who was independently acting, and that he should bear no legal responsibility. But because there are so many opportunities for Pandora's box to be opened about his finances, about what kind of orders he gives and directives, and of course about compensation, this is a very interesting deposition that everyone wants to hear, and frankly, most lawyers want to be able to depose him on.
Right, and you said it is fair game now, and you're talking because he's a former president, he cannot shield himself now. While being a sitting president, you can do so. So then I wonder, as we heard from Kara, while you have prosecutors in this case who might want him to explain his net worth, of course that's information that the Southern District of New York is going to be really keen to hear. So how might testimony from this deposition either assist further or in some way be used in other investigations, ongoing investigations?
Well, you're right. Not only is this about a former president, remember this is conduct coming out of 2015 when he was not even yet the president of the United States. You're going to have an even a bigger point of interest because he can't have said this was during the term of his office. But also the idea of trying to cross-reference. Remember, prosecutors spend a great deal of their time when they're looking at evidence, trying to corroborate what they believe they know. They may have the witness talking about something, the written testimony someplace else, other people being deposed. They're going to want to cross-reference whatever he says. And as the old phrase goes, Fred, whatever you say can and will be used against you in a court of law. Remember, whatever information he provides, if it is inconsistent in some way with what's already on the record or what the SDNY knows or the Manhattan DA's office knows or the AG's office knows in New York, all of these various entities, he'll be in a world of hurt, legally speaking.
Wow, there's potentially a lot at stake for him. So then we also know that, this may not be the only time Trump is ordered to testify. Listen to what U.S. Congressman Adam Kinzinger said this morning right here on CNN, that the committee investigating the Capitol riot won't rule out subpoenaing him?
If we subpoena all of a sudden the former president, we know that's going to become kind of a circus. So that's not necessarily something we want to do up front. But if he has pieces of information we need, we certainly will.
All right, so what do you make of that possibility?
Well, the idea of a former president like Trump speaking is really important here because remember, what we don't know is what the January 6th Select Committee is trying to find out. What led to those events and what part did the executive branch head play in it? They've subpoenaed people who were speaking or corresponding with members of the White House that day. There are 4 people. We know Bannon has already sort of bucked the system and said, I'm not going to respond because there might be the assertion of executive privilege, which of course is odd here, Fred, because he was not working for the administration, and you can't just say by assertion of the privilege that I'm not going to appear. That means you just can't necessarily answer questions that might be responsive where it might apply. But as you know, that privilege belongs to the executive branch, and Trump is no longer a member of it. And so you've got the idea here of if he is subpoenaed, there will likely be a protracted litigation. He will likely assert the privilege, but it does not mean that he can't be responsive to anything, only that which might be deliberative and only that which the current president, frankly, is keen on asserting. Because remember, the executive privilege is about not the president, but the presidency. And there might be instances, frankly, where a sitting president wants to preserve communication between himself, say, and a deputy chief of staff or a chief of staff down the line.
Wow. And so even though Trump does not have executive privilege to assert, he's trying to do that because this week the January 6th Insurrection Committee is planning to vote on criminal contempt charges against Trump loyalist Steve Bannon, who claims he cannot testify because he is being shielded by President Trump and this executive privilege. So what happens if Congress votes to hold Bannon in criminal contempt?
Well, it'll be a vote to refer it for criminal prosecution of contempt. Remember, we're not in a court of law where you've heard the judge say, I'm now going to hold you in contempt, and it's almost an immediate state of offense. We're talking about a referral that can then be given to a grand jury, and it's not often used in any instance. You don't have a long track record of when it's happened. You have had cases in the past, I think it was in the 80s, where the referral took about 8 days for the grand jury would actually indict on that point. So you do have that process, but you still have to have the conviction and or acquittal, so it could be a longer process. But in any event, the issue of privilege is quite resolved. You don't just get to say, if you have attorney-client privilege, Fred, or say a spousal privilege, you can't just say, I'm not going to show up. That privilege has to be asserted in response to a question that actually is about the nature of that privilege. If you're talking about what your name is, where you were, what other conversations you may have had, the responsive documents, et cetera, there are a whole host of things you could actually provide without even offending the privilege. And so for Bannon or Trump or anyone else who's been subpoenaed to simply say, I don't have to come because I might have a prospective claim that I still have to substantiate would be ridiculous. And of course it goes again. The entire notion of Congress and congressional power and congressional subpoena power, if the everyday person just thumbed their nose at a subpoena, what would be the power of the Justice Department, the power of Congress? It would really be reduced to nothing and more symbolic. Yeah. And if you care about a democracy, those have to be more than just symbolic gestures of an assertion of power.
Yeah, it's your boy. You the house boys. बाल तेरे सिल्की सिल्की हाँ बातें कर दिल की हाँ बाल तेरे सिल्की सिल्की हाँ बातें कर दिल की हाँ इतनी सोहनी हंसी है तेरी आय हाय इतनी सोहनी हंसी है तेरी करे मुझे किल में हाँ करे मुझे किल में हाँ hey girl चल संग महंगे वाले होटल में चल संग महंगे वाले होटल में फिक्र कर तू बिल की ना बाल तेरे सिल्की हाँ बातें कर दिल की हाँ बाल तेरे सिल्की हाँ